Rights of data subjects. Part 7 of the Act stipulates the rights of data subjects. The Act has enhanced the rights to access, rectify, erase, and restrict the processing of personal data. New provisions have been made to cater for decisions which are based on automated processing and the right to object to the processing of personal data by individuals. Right of access, Section 37. First, the right of access. A data subject has the right to obtain confirmation that his or her personal data is processed and a copy of the data free of charge within 1 month following a written request. How to make a request of access? You should write to the controller or fill in the new Rights of Data Subject form, which is available on this office website. Can a controller charge a fee for dealing with a subject access request? The controller must provide a copy of the information free of charge. However, where the request is manifestly excessive, he may charge a fee for providing the information or taking the action requested, or he may not take the action requested. Case study. Mrs. B had concerns about her daughter Rosie's school performance and so made a request on Rosie's behalf for her education records. Rosie was aged 8 and in grade 3 at primary school. The school asked for a fee of 1,000 rupees, which Mrs. B paid. The school provided the records, which consisted of 2 pages, 60 days later. This case is about access to education records and timescales and fees for subject access requests. What should be noted in this case? As per Section 37, subsection 5, the school should have provided a reply within 1 month from the date of request, but instead took 60 days. The information should have been given free of charge since the information is manifestly not excessive, as only 2 pages were provided. Automated individual decision making. A data subject has the right not to be subject to a measure which is based on profiling by means of automated processing. Examples of some fields where profiling is being carried out to aid decision making: banking and finance, healthcare, taxation, insurance, marketing and advertising. When should a controller carry out an automated individual decision-making process? When it is necessary for the entry into or performance of a contract, or it is authorized by law applicable to the controller, or it is based on the individual's explicit consent. Automated processing cannot be applied to special categories of personal data as specified in Section 2 of the DPA. What are you required to do? If the controller is making automated decisions as described in Section 38, subsection 1, it must identify and record its lawful basis for the processing. Inform the data subject that it is engaging in this type of activity and explain the significance or envisaged consequences of the processing. Have processes in place for people to exercise their rights. Bring details of data subjects' rights to their attention. It must secure personal data in a way that is in the interests and rights of the individual and that prevents discriminatory effects. Rectification, erasure, or restriction of processing. Data subjects have the right to obtain from the controller rectification of inaccurate or incomplete personal data concerning him or her without undue delay. Request that his or her personal data are erased without undue delay if the continued processing of those data is not justified. Request that the processing of his or her personal data is restricted where the accuracy of the data is contested or where he requires it for a legal claim, amongst others. See the exceptions provided under Sections 39, subsection 3 and 4 of the DPA. Example: a medical record of an operation must not be changed, in other words, updated, even if findings mentioned in the record later on turn out to have been wrong. In such circumstances, only additions to the remarks in the record may be made, as long as they are clearly marked as contributions made at a later stage. What do you need to know on the right to object? Data subjects have the right to object in writing on grounds relating to their particular situation to the processing of personal data. Controllers must cease such processing unless they demonstrate compelling legitimate grounds for the processing which override the interests, rights, and freedoms of the data subject, or requires the data in order to establish, exercise, or defend legal claims. Example: a controller has received an objection from a data subject regarding the use of his personal data for direct marketing. What should the company do? Stop processing personal data for direct marketing purposes as soon as the controller receives an objection. Deal with the objection to processing for direct marketing at any time and free of charge. If necessary, review the procedures of the organization. Inform individuals of their right to object at the point of first communication and in the organization's privacy notice. Where a person is a minor or physically or mentally unfit, a person duly authorized, that is, parents, guardian, legal administrators, can exercise their rights on their behalf under this part. If you have any queries regarding data protection, contact the Data Protection Office for advice.